What's up, guys? Welcome to Lawsplaining, the internet abridged version. This is a summary companion video to the South Dakota versus Wayfair decision. If you are interested in the full analysis, it's an hour and a half long. I go through the entire words of the main opinion and also Justice Roberts' dissent. I highly recommend it if you care about what the Supreme Court is saying and you want to know. This is a summary of that, okay? This is a summary. I'm going to try and keep this video short, and I'm going to try not to, kill someone, because I really, really hate this decision. Okay, this is South Dakota versus Wayfair, Inc. South Dakota as a background. Well, let me just go ahead and read what the court says. State of South Dakota brought action against internet sellers with no employees or real estate in the state, seeking declaration that these sellers had to comply with recently enacted statute requiring internet sellers with no physical presence in the state to collect and remit sales tax. Following an unsuccessful attempt to remove the case to federal court, the Circuit Court, 6th Judicial District, Hughes County, Mark Burnett judge, entered summary judgment for the sellers, which means the state lost. The state appealed, and the Supreme Court of South Dakota affirmed, meaning the state lost again at the Supreme Court of South Dakota level, holding that the statute violated the Dormant Commerce Clause. Cert was granted. So the Supreme Court takes the case. If you missed that, South Dakota is trying to tax internet sales that happen from retailers in other states with nobody in South Dakota, because there's like 5 people in South Dakota total, and they don't own stores, apparently. So if you're in South Dakota and you want to buy something from someone who's got a business in Delaware, South Dakota wants to tax you on that transaction. Okay? And prior to this ruling, they couldn't do it. I mean, they could. It's called a use tax. You were required to pay it, but they didn't require the seller to collect the tax and remit it to the state, because it's really, really inconvenient for a seller to do that. So let's see what the holdings are. Justice Kennedy held that 1. Out-of-state seller's physical presence in taxing state is not necessary for state to require seller to collect and remit its sales tax. Overruling Quill Corp and National Bellis Hess, 2 long-standing decisions. Number 2, stare decisis. That's the precedent that is binding on the Supreme Court. So past Supreme Court decisions are binding on the court through stare decisis unless a series of tests are overcome to justify overturning the decision. Stare decisis did not support Supreme Court's continuance adherence to Quill's unsound and incorrect physical presence requirement, and South Dakota statute satisfied substantial nexus requirement for imposing on internet sellers duty to collect and remit sales tax. That's the one I want to talk about most. Okay, so the long-standing rule on collecting a sales tax is that the tax has to have a substantial nexus to an activity that the state has the power to tax. Okay, no state should have the power to tax your online purchase in a different state. It shouldn't. It shouldn't. Why does it? What does it do? Let me tell you what it doesn't do. Kennedy says it does, but let me tell you what it doesn't do. It doesn't provide for police or fire protection. That is provided for by local property taxes, okay? So state sales tax? Nope, not that. Doesn't provide for roads. That's your gas tax and your car registration tab, your tabs and all that stuff. Your license fees, all of those things tend to pay for transportation and roads. Banking? Nope. Banking has its own taxes. Internet? Nope. You pay taxes on your internet service. You pay taxes on your phone service. You pay taxes on your on mail. Mail is partly taxed. All of this stuff, anything that you would use to facilitate this transaction in your state, is already paid for by other taxes. So the only thing that happens is this transaction, the sale of goods from them to you, that happens where the retailer is, not where you are, in my humble opinion. Now, you may disagree. That's fine. I haven't seen a compelling argument to the contrary. But Kennedy rules that the physical presence is no longer a requirement and that the substantial nexus is satisfied merely by clicking. This dummy thinks that a cookie on your computer manifests a physical presence. Okay, so that when you go to Amazon and a cookie is on your computer, now Amazon is literally in your house physically. That's how old Anthony Kennedy is. Okay, guys, this is a bad decision. If you wanna see anything other than me just complaining about it, which I do a lot of, watch the hour-and-a-half version. Just know that because of this decision, a state can force retailers all over the country to collect taxes on sales just by the product entering the state. Which also means that municipalities can too. So in Minnesota, for example, different towns have enacted their own different taxes, and in a lot of other places. In fact, there are 10,000 different taxing entities. So if you're a small business person who sells things online and ships them out, you now have to potentially comply with up to 10,000 different requirements. Thank you, Supreme Court. Thank you. Good job. Good job, you fat old idiots.